So shall we begin? Good morning. Good morning, everyone. I welcome you all on behalf of Vidya Vijay Foundation. This session aims to enlighten us all on a comprehensive analysis on Bharatiya Sakshya Adhiniyam 2023. It takes immense pleasure for me to call Dr. Nityanand Singh, founder and partner, Nux Legal Advocates and Solicitors. This session will be taken up by Mr. Singh, who is a member of Honorable Supreme Court of India and fellow member of Institute of Company Secretary of India. He has secured doctorate in law. Mr. Singh is an advocate by profession and practicing at Honorable Supreme Court of India. He has extensive experience of more than 20 years in litigation. Mr. Singh is a founder and partner of an international law firm named Nux Legal. Nux Legal has been operating as a corporate law firm in retail concept and currently handling litigation matters in more than 500 districts in India and abroad. Mr. Singh is also running an NGO with the name and style Vidya Vijay Foundation and serving the poor and needy people for upliftment of their education, social and living standards. The name Vidya and Vijay came from the name of the parents of Mr. Singh. The first word is the name of his mother, Mrs. Vidyadhari Devi, and father, Dr. Vijay Narayan Singh. Mr. Singh is a visiting faculty of IIM, ICSI, ICAI, and various other law colleges and business schools in India. Mr. Singh is also socially and politically active and contested the election of Legislative Assembly at Delhi twice. Now, I would like to call upon Dr. Nityanand Singh to proceed with the session and embark all of us upon this topic with his knowledge and wisdom.
Thank you, Ms. Yaska, for such a wonderful introduction. We'll start with, earlier we have covered the topic BNS and BNSS also, because there are the three new acts came into the force. Bharatiya Nyaya Sanhita, BNS, Bharatiya Nagrik Suraksha Adhiniyam, BNSS, and the third one we are going to cover on, that is the Bharatiya Sakshya Adhiniyam. There are the three new acts came into effect from 1st day of July 2024. So we always try to enlighten the new provisions of the act. This is entirely the new act. Therefore, we try to cover all what are the basic changes take place in the Indian evidence from Indian Evidence Act to Bharatiya Sakshya Adhiniyam. So we will share the PPT and we will move further. And if any of learned friends, this is the one-to-one sessions. If any questions, queries, then certainly you are most welcome. You can ask in between also, please. Bharatiya Sakshya Adhiniyam 2023. A comprehensive analysis. So first of all, we will look at certain provisions of the law when the bill was introduced. Bharatiya Sakshya Adhiniyam 2023. The introduction of the bill, the Bharatiya Sakshya Bill 2023 was introduced in the Lok Sabha on August 11, 2023. This is the basic background. That we have to understand what is the basic background, what is the intention came into the effect of this new act, why there was some requirements. Because the earlier the Evidence Act was 1872, pre-independence era. So that was the very old act. Therefore, there was a need for the change. Because the society is keep on changing each and every day. Therefore, we have to change the law accordingly. Bharatiya Sakshya Bill 2023 was introduced in the Lok Sabha on August 2023, 11th August 2023, to repeal and replace the Indian Evidence Act 1872, the basic aim and objective to repeal and replace the Indian Evidence Act 1872, pre-independence era. This act came into the force. Accompanying legislation, the bill was part of the larger initiative along with two other bills to replace the Indian Penal Code and the Code of Criminal Procedure. We have already covered in the earlier session Bharatiya Nagrik Suraksha Sanhita (BNSS) and BNS. We have that has been replaced the Indian Penal Code and Code of Criminal Procedure. Withdrawal on reintroductions. The original Bharatiya Sakshya Bill 2023 was withdrawn on December 12, 2023. The Bharatiya Sakshya second bill was introduced as it is its replacement. Bharatiya Sakshya Adhiniyam 2023 legislative progress. What is the we will cover within 2-3 minutes. What is the background? The bill was passed by the Lok Sabha on December 2023. The passed by the Rajya Sabha on 21st December 2023. It was passed by the Lok Sabha in December 2023. Passed by the Rajya Sabha in December 2020, December 21-23, and bill received the President assent on December 25, 2023. I would like to again reiterate the facts that the day when the Act become in force, when it is published in the official gazette after the assent of the President. Unless and until there is a assent of the President, it never become the Act. Unless and until it has the assent of the President, it is always a bill. But once there is a assent of the President, then it become Act. There is a difference between the bill and Act. So we can understand what is the basic difference between the bill and Act. And it will be effective from the date which is notified in the official gazette. So once notified, it will be called the Bharatiya Sakshya Adhiniyam 2023. What is the objective of the BSA? Because it is notified in the official gazette on 25th December 2023. It is become the Act, but it came into the effect. It is notified in the itself that it came into the effect from the first day of July 2024. The object of the BSA, Bharatiya Sakshya Adhiniyam, is designed to modernize and streamline the law of evidence in India, reflecting the advancement in technology over recent decades. As an adjective law, the BSA facilitates the operation of the substantive and procedural law by defining how evidence is presented and assessed in the courts. It broadens the definition of the evidence to include electronic, because this is the very important thing. The main intention to introduce the new act, because there is some digital market evolved in the current era, and that digitalization has not been covered by the earlier act, the Evidence Act, because this Indian Evidence Act came into the force in 1872. Thereafter there are the certain changes had takes place, and in the era of the electronic gadgets and all those digital market, these digital evidence has to be recorded and it has to be taken as an evidence. Therefore, the new act basically to cover all those digital data. The Bharatiya Sakshya Adhiniyam 2023 has covered all those data and all those if it is recorded by the video phones, that is also can be produced as an evidence. So to cover all those digital records, this new act came into the force. It broadens the definition of the evidence to include electronic and digital records. These two words, electronic and digital records, were not in the earlier Indian Evidence Act, ensuring their admissibility with the same legal standing as traditional documents. Because earlier there was some traditional documents, whatever the traditional documents can be produced as an evidence, but now all the electronics and digital records can also be produced as an evidence. Additionally, it expands the scope of the secondary evidence and introduces precise rules to enhance uniformity in the court practices, thereby improving the reliability and efficiency of the legal process. What is the main important sections we will discuss? Earlier in the Indian Evidence Act, now in the Bharatiya Sakshya Adhiniyam BSA, evidence may be given of facts in issue and relevant facts. It was earlier section 5, but now it is section 3. There is a comparison. Relevancy of the facts forming part of the transactions. It was earlier in section 6, now it is under section 4. Facts which are occasion, cause, or effect of facts in issue are relevant facts. Earlier it was under section 7, now it is under section 5. Motive, preparation, and previous or subsequent conduct. Now it is covered under section 6. Earlier it was under section 8. There are the only difference in the sections, but almost provision is the same. Facts necessary to explain or introduce fact in issue or relevant fact. There are some basic changes you will discuss later on. Section 9 and here is in section 7. When facts not otherwise relevant become, because we are only cover which are the very, very important for the evidence, not cover the entire thing, because almost every section has been changed. When facts not otherwise relevant become relevant, earlier it was covered under section 11, now it is covered under section 9. Proof of the facts by oral evidence, section 59, and it is now 54. Examination of witnesses, 137, 142. Confession to the police officer. It was earlier deal with section 25 to 27. Now it is deal with section 23. There are the certain changes also takes place, but we will discuss and cover all those. Changes to section 1. This is very important, very, very important to draw your attention. Then what is the major section change in this changes to section 1? That is the very first section. That is a major change. It impact is a very broader. Indian Evidence Act 1872 provided that it extended to the whole of India. The word whole of India was written in the 1872 Indian Evidence Act, whereas the Bharatiya Sakshya Adhiniyam 2023 exclude this provision of the territorial extent. Means this Bharatiya Sakshya Adhiniyam 2023 is not only restricted to the India only, but it also extends to the other countries. It will be covered how it is implicated, because if it is some offense has been committed in the not only in other countries, and that evidence can be produced in India, and that is valid. So this is a very major change, that the word whole of India being deleted, and it covers the entire world. So it is the basic interpretation of the law, because it may be the intentionally this word has been not be included in the Bharatiya Sakshya Adhiniyam, that is the extended to the whole of India. The possible reason for each omission is that for such omission, that any stipulation that the BSA extend to the whole of India would fall into the question the admissibility of the evidence digitally generated outside the borders of the India. If any evidence in the form of the digital form, which is outside of the India, that evidence can also be produced in India. So this is the basic intention of the legislature, what I can interpret, but everyone has their own interpretation. Changes to section 1. Section 1 of the Indian Evidence Act provided that said act did not apply to the court, because earlier this act was applicable to this Indian Evidence Act was not applicable to the court martial. Section 1 of the Evidence Act provided that the said act did not apply to the court martial convened under the Army Act, Naval Discipline Act, or Indian Navy Discipline Act, or the Air Force Act. This act was Indian Evidence Act was not applicable to the court martials, but now all those word has been removed, and now it is applicable to the court martial as well. Section 1, subsection 2 of the BSA, this is a new act, omits the word convened under the Army Act, Naval Discipline Act, or Indian Navy Discipline Act, or the Air Force Act. It has been deleted. Thus, unlike the Evidence Act, the BSA shall also applicable to the court martial convened under the Army Act, Naval Discipline Act, Indian Navy Discipline Act, or the Air Force Act. Means now the Bharatiya Sakshya Adhiniyam 2023 is applicable to the court martial. Got it? Electronic and digital records, that is very important. new definition of the document. Already there was a definition of the document in Indian Evidence Act, but there are the certain new things covered under the Bharatiya Sakshya Adhiniyam 2023, because basically we are here, what is the basic changes takes place in the Indian Evidence Act and Bharatiya Sakshya Adhiniyam. I am only cover those changes. Section 2(1)(d) of the BSA introduces a new definition that are compatible with the modern digital era. New definition specifically includes electronic and digital records as documents. That word digital records was not in the Evidence Act, but now the word digital record introduced in the section 2(1)(d) of the definition of the documents. So all those digital records will be treated as the documents, because earlier only the documents in the physical form only be treated as the documents, but now digital records is also treated as the documents, because there was no such word used in the Indian Evidence as digital records. Statutory illustrations relates, because once we are going to the Indian Evidence Act definition of the documents, there are the certain illustration has been given. What are the documents are included? There are the five illustrations are already given in the Indian Evidence Act. There is a new sixth illustrations has been added in the definition of the word document. Statutory illustration retain five statutory illustrations from the old definitions. Add a sixth illustration. This is the new thing introduced in the Bharatiya Sakshya Adhiniyam, which was not earlier found in the Indian Evidence Act. That is the sixth illustrations: electronic records on emails, server logs, documents on computers, laptops, smartphones, messages, website, locations, evidences, and voice email messages stored on the digital devices are considered documents. This is the new sixth illustrations has been added in the Bharatiya Sakshya Adhiniyam. So what are the changes? We keep on concentrating what are the changes takes place. Electronic and digital records, expanded criteria for document or documentary evidence. There is a certain definition of the evidence has also been given in the Indian Evidence Act, but there are certain additional words has been added, not necessary for the matter to be expressed or described, only the letters, figures, or marks. Any matter otherwise recorded. This word otherwise recorded has been introduced in the Bharatiya Sakshya Adhiniyam BSA. Any matter otherwise recorded by any other means qualifies as a document or documentary evidence. Otherwise recorded means if in the form of any form you have recorded something, then this is also the form of also the part of the evidence. Implication for the video recording. Video recordings on mobile phones qualify as documentary evidence as they are otherwise recorded by any other means. So there are the words added, otherwise recorded by any other means. These two words, because in the legal language, every word is very important, and whatever word is written by the legislature, it is important, and you have to interpret each and every word. So this word added, otherwise recorded by any other means. In any other means, if you are recording anything, and that can be admissible as an evidence. Corresponding provision, section 2(1)(e) of the BSA corresponding to section 3, para 6 of the Evidence Act. In Evidence Act, whatever the definition has been given in the section 2(1)(e), this is the relates with the documents. It was earlier defined in section 3 and para 6. Electronic digital records, new definition of the evidence. Section 2(1)(e) of the BSA introduced a statement, including a statement giving electronically as evidence. This word electronically as an evidence has been added. These statements are treated as both evidence and oral evidence. Logical corollary correlates with the section 530 of the Bharatiya Nagrik Suraksha Sanhita 2023, because whatever the electronic records and electronic documents that has been inserted in the Bharatiya Nagrik Suraksha Sanhita 2023 as well. In section 530 of the, we have already discussed when we have taken the session of the Bharatiya Nagrik BNSS. That is section 530 especially talks about provides for the examination of the complainant and witnesses electronically. This was also the new section has been introduced, that every complainant and witnesses may be examined electronically. Means there is some examination in chief and cross examination can be done through electronic modes, means digital mode, through virtual, utilizes electronic communications or audio video electronic means. Nowadays, because sometimes you are appearing before the court and you are also attending the hearing through video conferencing. So these video conferencing system examination and cross examination can be conducted through video conferencing. This has been introduced and under section 530 of the Bharatiya Nagarik Sakshya Adhiniyam 2023 BNSS. Previous definition under Evidence Act, only electronic records were treated as the documentary evidence, and there was no express mention of the digital records in the definition of the evidence. These word digital records were not mentioned in the definition of the evidence, but now the digital records were specifically inserted in the definition of the evidence. A specific inclusion under the BSA section 21E of the BSA specifically includes electronic or digital records as documentary evidence. So these has to be relevancy of the facts forming part of the same transactions. Corresponding section 4 of the BSA, corresponding section 6 of the Evidence Act, facts not in issue, section 6. These some words have been inserted in section 6. Facts not in issue. Section 6 of the Evidence Act, facts not in issue but connected with the fact in issue as part of the same transaction are relevant. It was earlier in the Evidence Act. Now section 4 of the BSA says extends relevancy to the facts connected with the relevant facts. Here the word, earlier the word was fact in issue. Now the word used relevant facts as part of the same transaction. Earlier, the fact which are related with that issue only was covered. But now, if any fact which is the relevant to that issue, that is covered under this Sakshya, BSA. So these two words, fact in issue and relevant fact. In place of the fact in issue, this word, relevant fact, has been inserted. Exclusion of the section 22A means section 22A has been deleted. That is not covered under the Bharatiya Sakshya Adhiniyam. Oral evidence on electronic records. Section 22 of the Evidence Act dealing with the oral evidence as to contents of the electronic records has been excluded from the bill. This has not been covered under the Bharatiya Sakshya Adhiniyam. Now the confession. Earlier it was also included under, it was covered under the Indian Evidence Act, but there are some new words have been introduced. Significant modification in the section 24, section 22 BSA. Earlier it was section 24, now it is section 22 of the Bharatiya Sakshya Adhiniyam of the Evidence Act. Original provision, any confession made by an accused person caused by inducement, threat or promise is irrelevant. Means if you are confessing anything by force, coercions, threat or promise, those are the irrelevant. The word coercion, the word coercion was not earlier in section 24 of the Indian Evidence Act. Any confession made by any accused persons caused by, this was the only word, inducement, threat or promise. But now the word coercion is also inserted. Coercion is one of the acts now to make the confession irrelevant. New provision introduced, removal of the influence, and there are certain provisions are also added. Earlier there was under section 24 there was no provision, but there is under section 22 Bharatiya Sakshya Adhiniyam BSA there is a new provision added, removal of the influence. Any confession becomes relevant in the court's opinion. The inducement, threat, coercion or promise has been fully removed. Means there are certain removal of the influences. Means it is admissible in evidence if it is in the prima facie, it is presumed by the court that yes, this is the relevant, then it can be proved as irrelevant. There is some provision added in the section 22 to BSA. Confession. Certain confessions remain relevant. Earlier, under the Indian Evidence Act, this was not the provision, but this is the provision added in the BSA. Which confession is relevant? Certain confessions remain relevant. Confessions made under the promise of the secrecy. If on the secret issue that you are saying that you should not disclose to anyone, you are confessing something, then it is relevant. Certain confessions remain relevant. Confessions made under the promise of the secrecy. Promise of secrecy means if you want to say something very secret, then it can be remain relevant as in confessions. Confessions obtained through deceptions practiced on the accused. Confessions made while the accused was drunk. Even under the Bharatiya Sakshya Adhiniyam, if the accused was in the drunken conditions and made certain confessions, then these confessions may be the relevant one. Because this new has been, because earlier it was that if any person is a drunken person and who is not in the sound mind and giving some confessions, that cannot be relevant. But now it is confessions made while the accused was drunk, it is relevant. Confessions made in response to the questions that the accused need not have answered, regardless of the question's form. If anything is not in the question forms, but you are confessing something, then that is also relevant. Confession made without warning that the accused was not bound to make it and that it could be used as evidence against them. If you are, because earlier it was giving a warning and saying that whatever the confession you are making, that can be used against you as an evidence. But now, even though you are not saying like that, and the accused person is confessing something, that is also relevant. This is not mandatory that, yes, you should say like that, that whatever the confession you are giving, that can be used against you. Clarification, these provisions may need further clarification to ensure they do not infringe on the rights against self-incrimination. Because there is a provision in the Act that the accused cannot give evidence against whatever, against himself, that cannot be bound to give evidence against himself. Digital signature. Modification section 45 of the Indian Evidence Act, section 39 under BSA. Inclusion of the examiner of the electronic evidence. The opinion of the examiner of the electronic evidence as per section 79A of the IT Act is now considered relevant fact for the information stored digitally. Whatever the opinion, inclusion of examiner of the electronic evidence, whoever is the examiner of electronic evidence, that opinion of the examiner of electronic evidence is relevant now. Consolidation of the provision on handwriting and digital signatures. Provision related to the opinions on the handwriting digital signatures previously under section 47 and 47A had been combined into section 41. Earlier it was covered under section 47, 47A. Now it is both sections has been combined and covered under section 41 only. So section 39 BSA, the opinion of the examiner of the electronic evidence under section 79A of the IT Act is now considered relevant after the information is stored digitally. Whoever the opinion given, that is the relevant. Facts which need not to be proved. Now, half an hour, there is a one-sided communication is going on. Therefore, I would like to say that yes, if anyone has any questions, any issue, then certainly we will discuss and further go ahead, because there should be not any one-way communications. Yes, dear friends. Am I audible?
Yes, sir, you are audible.
Is there any question? Is there any query? Then we will discuss that question and query, then we will proceed further. Yes, please. किसी की कोई क्वेश्चन नहीं, कोई क्वेरी नहीं? Yes, say something. Am I audible, not audible?
Yes, sir, you are audible.
There is no other response apart from you.
Hello. You are audible, sir.
Is there any question, query, or you can go ahead?
Go ahead, sir.
Thank you. Thank you. To be proved. Amendment to Section 57, Section 52 of the BSA of the Evidence Act. Inclusion of extraterritorial laws. Whatever we have discussed in there is change in the Section 1. That word whole of India has been intentionally excluded from the BSA. Amendment to Section 57, Section 52 of the BSA, the Evidence Act. Inclusion of the extraterritorial laws. All laws in force in India with extraterritorial operation are now included within the scope. All laws which are not only applicable in India but also applicable to the other countries. All laws in force in India with extraterritorial operations are now included within the scope. Expansions of the international context. The section now encompasses international treaties, agreements, and conventions involving India. Whatever the international treaty, they can also be produced as an evidence in India. Decision made by India at international association and bodies are also covered. Facts which need not to be proved. Exclusion of UK specific references. References to seals, proceedings, and sovereign concerning the United Kingdom have been excluded. There are the certain exclusion. Facts which need not be proved. Exclusion of the UK specific references. References to seals, proceedings, and sovereign concerning the United Kingdom have been excluded. Means whatever the document that has already been proved in other country, that can be also produced an evidence which need not to be proved. Focus is limited to similar authorities within India, ensuring parity with the international treaties and authorities involving India. Significance: these changes streamline the evidence process by clarifying which facts are assumed to be known and do not require proof in legal proceedings, particularly in the context of the international law and India's role. There are the certain things, certain documents which need not to be proved in India. There are the certain international treaties, references to seal, proceedings, sovereign concerning the United Kingdom. These all are the excluded to prove in India. Primary evidence, Section 57 BSA. Recognition of the uniform process documents. Documents produced using uniform processes, printing, lithography, photography are considered primary evidence of their own content. There are the primary evidence. There are two types of the evidences, primary evidences and secondary evidence. So whatever the documents, printing, lithography, photography are considered as the primary evidence of their own content. Copies of the common original are not primary evidence of the original content. Electronic or digital records. Each electronic or digital file is treated as the primary evidence. These electronic records will be treated as the primary evidence. An electronic record from proper custody is primary evidence unless disputed. Video recordings stored or transmitted electronically are primary evidence. These are the primary evidence. Multiple storage spaces. Electronic records stored across multiple storage spaces in a computer resource are all considered primary evidence, including temporary files. Key points: the modifications broaden the scope of what constitutes primary evidence. Modifications broaden the scope of the what constitutes primary evidence, particularly in the context of the digital and electronic records, ensuring clarity and consistency in the legal proceedings. What are the primary evidences? There is some broadened definitions has been given for the primary evidence. Now come into the secondary evidence, because there is a difference between the primary evidence and secondary evidence. Section 63 Indian Evidence Act, expansion of the categories. The new provision includes additional categories such as oral admission, written admissions, evidence from the person examining a document. The scope of the secondary evidence, broader than the original Evidence Act, now encompasses oral and written admissions, also includes evidence taken by the skilled persons from an original document that cannot be directly examined by the court. If there are, this is the secondary evidence. If any persons, expert persons, are giving their opinion on particular things, suppose if you are approaching to the handwriting experts and your handwriting experts have given certain evidence, that can be treated as secondary evidence, and that is already proved. Requirements for secondary evidence: oral evidence must specifically relate to the original document, not a copy, to qualify as the secondary evidence. The expanded categories of the secondary evidence will assist courts in determining the admissibility of the documents and other forms of the evidence. Electronic evidence. This is important, and you have to focus on it. Simplification of the contents. The provision under Section 65B has been streamlined for clarity. Earlier, there was a, if you are giving any electronic records before the court, then it has to be supported by the affidavit, supported by an affidavit under Section 65B of the Indian Evidence Act. So whatever the documents is electronic document, it has to be supported by an affidavit under Section 65B of the Indian Evidence Act. Electronic and digital records are considered legally equivalent to paper records in terms of the Section 61 BSA, subject to Section 63 BSA. So all the electronic records will be treated as a documents. Electronic and digital records are considered legally equivalent to paper records, because once was giving some paper records, that was a primary evidence, and in the same format, whatever you are giving the digital records, that will be equivalent to the paper records in the effect, validity, and enforceability. This is the new introduced in the BSA. Presumption as to the document. Expansion of Section 81A deals with the presumptions as to the gazette in electronic or digital form. Includes an additional explanation of the proper custody. These two words, presumptions as to the gazettes in the electronic or digital form, includes an additional explanation of the proper custody. Section 82, presumptions about the documents admissible in England has been excluded from the bill. Presumptions about documents admissible in England has been excluded from the bill. Presumptions as to the document. Modification of Section 86 Indian Evidence Act, Section 88 BSA excludes reference to the dominion of the Great Britain. These all are the words being excluded, because earlier it was under the Indian Evidence Act written, but all these words have been deleted, not been included in the BSA. Presumptions as to the documents. Modification Section 86 80 BSA exclude reference to the domains of the Great Britain. Adopts a nomenclature to indicate documents from the any country beyond India. These words have been excluded. Reference to the dominion of the Great Britain, it has been deleted. Adopts a nomenclature to indicate documents from any country beyond India. Simple words have been written, any documents beyond India. Alternate to Section 81, 80, Section 90 BSA replaces the phrase telegraphic message with electronic message. The earlier it was the word telegraphic message, because there was some telephone and all those things, and now it is with the electronic message. The word has been changed, replaced. Telegraphic message word has been replaced by the word electronic messages. Now accomplishment. Words merely because are replaced by if. Words merely because. These words merely because are replaced by if. This clarifies that a conviction of the accused is not deemed illegal when it is the based on the corroborated testimony of the accomplice. The original provision stated that the conviction is not illegal merely because it proceeds upon uncorroborated testimony of the accomplishment. The earlier section, the accomplishment, which was deals with section 138(1). Now, the earlier accomplishment word, I will read the definitions of the accomplishment earlier. What is the definitions of the accomplishment? Accomplish. For the better clarity, I will read the definitions. Section 138, accomplish. Earlier, it was section 133 of the Indian Evidence Act. But first of all, I will read section 133 of the Indian Evidence Act. What is the say of the 133? Because there is some clear-cut definitions you can understand. Accomplice. An accomplice shall be competent witness against an accused person. An accomplice shall be the competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of the accomplishment. Means, if any persons who are accomplice to you and given an evidence and you are being convicted, then it cannot be presumed that this conviction is illegal only because of that it proceeds upon uncorroborated testimony of the accomplishment. But now the word, because once you will read it, accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely. Here these words are important because it proceeds upon the uncorroborated testimony of the evidence. These word is being because it proceeds upon the uncorroborated testimony of the accomplice. This was in the earlier Evidence Act, but now earlier section 133 and now the section 138. Accomplice. Accomplice shall be competent witness against an accused person, and a conviction is not illegal. This word is being changed if in the Indian Evidence says it was because. Section 133, once you will read it, the word is very important. The line till 138, accomplice shall be competent witness against an accused person and a conviction is not illegal. These words are the same in the both Indian Evidence Act and BSA. Accomplice shall be competent witness against an accused person and a conviction is not illegal. Merely, here the word in the Indian Evidence Act merely because, the word used because it proceeds upon the uncorroborated testimony of the compliance. And here in the Bharatiya Sakshya Adhiniyam BSA, now it is not word they use because, here the word is used if it proceeds upon the corroborated testimony of the accomplice. There are the 3-4 words changed in this Bharatiya Sakshya Adhiniyam. If corroborated testimony, and earlier it was uncorroborated testimony. So these are the basic differences. We have to understand that here the word used if clarifies that a conviction of the accused is not deemed illegal when it is based on the corroborated testimony of the accomplishment. The original provision stated that the conviction is not illegal merely because it proceeds upon the uncorroborated testimony of the accused. Earlier, there are the used word uncorroborated testimony. Now the word is using corroborated testimony, and earlier it was used because, and because word is being replaced by if. So there is a basic differences between because and if, and corroborated and uncorroborated testimony. So we have to understand what is there are the basic differences between two words: corroborated, uncorroborated, because, if. So these all are the provisions are the very important. Every word is the very important, and we have to understand each and every word and why this word is being used. Of course, there is some legislative intention that once new act come into the force, then they are trying to cover the entire things. So you have to basically understand the things very properly. Examination of the witnesses. Examination of the witnesses. Once the witness is being examined and being called, there are the certain questions, because this is the once you are examining the witnesses, this is also an the art, and there is a certain author has written the books in the only this topic, examination of the witnesses, how to examine the witnesses, what types of the questions you have to frame, which type of the questions you can ask, and which type of the questions can be denied by the court. Because sometimes you are asking certain questions and these are the relevant questions and not the relevant questions. Being an advocate, you can object accordingly. So this is also an art of the examination of the witnesses, and this is a good art, and every learned advocate should understand and learn the techniques to examine the witnesses, because the entire case, your entire case is depend upon how to examine the witnesses, because once the witnesses is coming into the witness box, the entire case is made. Suppose once I am taking an example. Suppose if any lady which the filing an FIR against any offences, and that draft, the complaint is drafted by basically by an advocate. He has put the particular points so that there are the certain sections can be inserted, because the general public is not aware about the law, which sections shall be inserted, which sections shall not be inserted, and what the words you should put in that particular complaint so that the particular section can be added. So once lady or gents, whatever, is not very literate about what are the contents has been added in the FIR, so that particular section can be inserted. But once they are appearing before the court, and it should be your knowledge and techniques to ask the questions, so you can prove yourself not guilty, and what is the truth can come from her or his mouth, because this is the text and tactics. So you have to learn these text and tactics so that the actual thing can be proved. Because once a person coming into the witness box, it may be possible he never appeared before the court. He is not able to sometimes answer the questions, but sometimes he is telling truth, because once you ask the question, because he has not drafted the complaint and he has not aware about all those contents of the complaint. Therefore, in the most of the cases, there is an acquittal of the accused. So you have to learn these techniques, how to draft and how to ask the questions, because your entire case, especially in the criminal law, there is no reply has to be given by you. The entire case depends upon the cross examination of the accused person. So it is very important to learn the techniques to cross examination of the witnesses, because we can prove yourself not guilty, and what is the truth come from the witnesses, because sometimes witnesses say yes, this is correct, this is not correct. Sometimes you are asked question, this is not correct, so they are not easily understand the words. Then you have to develop yourself, you have to develop your checks and techniques, how to proceed and how to examine and cross-examination the witnesses. So leading questions, modify section 140 of the Indian Evidence Act, new section 146. There are the certain leading questions you can ask. This is the questions. So before examining the witnesses, you have to frame your mind. You have to frame your questions as well. What are the relevant questions you are going to ask? And if your court is denied that yes, this is not the relevant questions, then what should be the next questions? You should be ready with that also, because you should not be demoralized that once the court has denied you that no, this is not the relevant question. So you should not lose your confidence. You should keep on continuing asking the questions so that the truth come from the witnesses who are coming to the witness box. So, and there are the questions. So there are the certain leading questions. Previously relied on the suggestive character of the questions. There are the, in the last, you have to also give the suggestion. What is the suggestive character of the questions means? Whatever the suggestion you are giving, that should be your defense. Because once you are the cross-examining any witnesses, at the end, your suggestion should also be there. Suggestive character means your suggestion should be there. Suggestion is your defense. Whatever the defense you are taking in your entire FIR or entire pleadings. So you should also, there are the, it is wrong to suggest, it is wrong to suggest, it is wrong to suggest. Even though you are saying that it is wrong, the witness is saying it is wrong, but that is very important for you to prove yourself that yes, that this questions has been in the asked in the form suggestive character, that this is my defense and we have taken proper defense in our case. Therefore, my case is admissible and my client accused person is being acquitted. So this is also very important. You may read certain books on this, how to that art of the cross examinations. There are specific books are written by the certain author, and this is the one of the important part of the advocacy. So you have to learn the techniques. New section includes specific circumstances or leading questions such as in cross examination matter which are introductory or undisputed. So there are the certain new sections includes specific circumstances. There are the certain specific circumstances for which you can ask the leading questions, such as cross examinations matters which are introductory or undisputed. So there are the certain questions you can ask in the examination, because there is some examination in chief and cross examination. So all those you have to understand. So we have tried to cover all those things in whatever the limited period of the time. So dear friends, then we will have a question answer sessions. If any one of us ask the questions, certainly we will deal with the now question answer sessions. There are only 2-3 minutes are left, so we can cover all those questions and answers if any query.
सर एक क्वेश्चन था.
हाँ बोलिए प्लीज.
सर क्रॉस जब हम करते हैं तो हमारा प्रोसीजर क्या होना चाहिए? पहले सजेशंस तो लास्ट में, इसका एक प्रॉपर एक थोड़ा सा ओवरव्यू दे दीजिए प्रोसीजर का.
देखिए, जब हम क्रॉस शुरू करते हैं तो सबसे पहले हमें क्रॉस में ये देखना होता है कि उनके एविडेंस में क्या क्या आया हुआ है. क्योंकि जो भी देखिए, जब अगर आप क्रिमिनल में क्रॉस की बात करते हैं तो क्रिमिनल में जो है उनका चीफ होता है, सबसे पहले चीफ होता है. तो चीफ में जो है जो भी गवाह जो है जो चीफ में कहता है उसी चीफ के बेसिस पे आपको उसी से रिलेवेंट क्वेश्चन पूछना होता है. जैसे मैं उदाहरण लेके आपको बताता हूँ. जैसे अगर किसी लेडी ने कोई कंप्लेंट की कि मेरे साथ जो है कोई अपराध हुआ है, तो समटाइम्स ऐसा होता है कि समटाइम्स उसके साथ एक्चुअल अपराध होता है, समटाइम्स एक्चुअल अपराध नहीं भी हुआ होता है तो भी एक कंप्लेंट फाइल हो जाती है।
जी सर।
अगर उसके साथ एक्चुअल अपराध नहीं हुआ है तब तो आपको ये उस लेडी से ऐसे सवाल पूछने हैं सबसे पहले कि जिन्होंने अपनी गवाही में कहे होंगे, गवाही में कहे होंगे कि मैं इतने समय यहाँ जा रही थी, वहाँ जा रही थी, इससे मिली थी, उससे मिली थी, इससे इतने बजे मिली थी, उन्होंने मुझे जो है कुछ दिया था या खाने के लिए दिया था, पीने के लिए दिया था, जिससे मैं किसी भी बेहोशी की हालत में चली गई, कुछ हो गया, इसके बाद उन्होंने मेरे साथ दुष्कर्म किया। ऐसा अगर कोई कंप्लेंट आता है तो तब
जी
आपको सबसे पहले ये देखना है कि भाई उन्होंने जो कहा कि इतने बजे गई थी, इतने बजे आई थी, इतने यहाँ मिली थी, यहाँ पे था, तो उसमें आपको ये देखना है कि भाई आप टाइम उसमें लिखा है कि नहीं लिखा हुआ है, उसका डेट लिखा हुआ है कि नहीं लिखा हुआ है, उसका उसका जो है उस प्लेस से क्या रिलेवेंसी है या नहीं, जिस
जी
प्लेस की बात कर रही हूँ उस प्लेस पे वो कभी गई हैं या नहीं गई, उस प्लेस की सराउंडिंग्स में क्या हो सकता है, उस प्लेस को उन्होंने देखा या नहीं देखा। जैसे अगर कोई
जी
कहता है कि मैं लाल किला गई घूमने के लिए, तो भाई लाल किला की सराउंडिंग्स में कुछ तो आपने देखा होगा कि आगे पीछे क्या है क्या नहीं है, वहाँ चांदनी चौक है या नहीं है, उसके अगल बगल क्या है, कोई मार्केट थी या नहीं थी। तो सबसे पहले तो आपको ऐसे सवाल पूछने हैं जिससे उनका कि भाई वो सही घटना है या नहीं है उससे आपको पता लगे, क्योंकि
जी
वो उन्होंने चीफ में कहा है, उस चीफ में से ही आपको सवाल पूछने हैं सबसे पहले।
जी जी
इसमें से सही जानने की कोशिश करनी है कि भाई एक्चुअल फैक्ट्स क्या है।
जी
जब आपको एक्चुअल फैक्ट्स पता लग जाएंगे, कि देखिए जब भी एफआईआर होती है तो मैंने बताया कि जब भी एफआईआर होती है तो वो जो है एफआईआर वो लेडी खुद नहीं करती है, कई बार वो
जी
उसके वकील साहब चेक्स एंड टेक्टिक्स लगा करके वैसे वर्ड्स ऐड किए जाते हैं उसमें जिससे पर्टिकुलर सेक्शन इंसर्ट किया जा सके।
जी
उस लेडी को कितना भी आप सिखा पढ़ा करके भेजते हैं कि ऐसा बोलना, ऐसा बोलना, ऐसा बोलना है, लेकिन आपकी यही है क्या कर सकते हैं टैलेंट, कि आप ऐसे घुमा फिरा के सवाल पूछें कि वो उसमें उलझ जाए। और अधिकतर जो है लोग उलझ जाते हैं क्योंकि उनके
जी
साथ वो घटना अगर नहीं हुई होती है तो वो सही क्वेश्चन का जवाब नहीं दे पाते हैं।
जी
और एक या दो वर्ड में अगर वो उलझ गए, अगर उन्होंने जो अपना गवाही दी मतलब चीफ दिया है और जो एफआईआर के कंटेंट्स हैं दोनों एक दूसरे से कंट्राडिक्ट करने लगते हैं।
जी
आपने जो गवाही दी और आपने जो एफआईआर है, अगर दोनों एक दूसरे से कंट्राडिक्ट करने लगते हैं तो आपका केस आप जीत जाते हैं।
जी
सबसे पहले तो आपको सवाल उसी पे पूछना है कि उन्होंने एविडेंस में अपने चीफ में क्या कहा,
जी
उसको आपको प्रूफ करना है। फिर आपके जो है इसको प्रूव करने के बाद जो है फिर आप भाई ये सही है, ये सही है, ये सही है, ये गलत है, ऐसे सवाल
जी
पूछते हैं। भाई मेरा कहना है कि आपने ऐसा किया, ये सही है,
जी
मेरा कहना है कि ये गलत है, तो वो सही और गलत का वो जवाब अपने आप देते हैं।
जी
उसके बाद जो है फिर आपके सजेशन आते हैं लास्ट में। सजेशन इसलिए
जी
आते हैं कि आपका डिफेंस क्या है।
जी
जैसे आपका डिफेंस ये होगा कि भाई मेरा कहना ये है कि मैं वहां पे कभी था ही नहीं, इट इज रॉन्ग टू सजेस्ट दैट आई वाज नॉट देयर, मेरी आपसे कभी मुलाकात ही नहीं हुई और ना ही मैं उस प्लेस के बारे में कभी जानता हूँ। ये सब
जी
आपके डिफेंस आते हैं।
जी
ये
जैसे इट इज रॉन्ग करेक्ट
रॉन्ग टू
दैट
सजेस्ट दैट, इट
इट
इज
इज
रॉन्ग
रॉन्ग
टू
टू
सजेस्ट
सजेस्ट
दैट
दैट आई
आई
वाज
हैव
नॉट
नेवर
देयर।
मीट विथ यू।
जी
जैसे ये होगा इट इज रॉन्ग टू सजेस्ट दैट आई हैव नेवर मेट विथ यू, ये
ये तो
कहना गलत है
अफर्मेटिव
कि
हो
मैं आपसे कभी मिला ही नहीं।
गया। जी जी ये अफर्मेटिव हो गया।
अफर्मेटिव नहीं, जैसे वो विटनेस कहती है, ये हम नहीं
जी
कह रहे
जी
हैं। विटनेस ये
जी
कहता है कि जो आप ये कह रहे हैं कि मैं कभी नहीं मिला, ये कहना गलत है।
जी जी
देखिए जब क्रॉस में जब आता है ना तो विटनेस का वो विटनेस की तरफ से वो शब्द आते हैं।
जी
तो हम जब सवाल पूछेंगे कि भाई मेरा यही क्वेश्चन है कि मैं आपसे कभी मिला ही नहीं,
जी
वो कहिए कि नहीं आप ये कहना गलत है, तो ये जाएगा इट इज रॉन्ग टू सजेस्ट दैट आई हैव नेवर मेट विथ यू, क्योंकि विटनेस बोलेगी ना। नहीं समझे? एम आई ऑडिबल विवेक जी?
जी सर जी सर
Yes, sir, we are audible.
क्लियर हो गया। पास्ट वुड
और अगर अगर जो है सिविल मैटर में अगर आप जाएंगे, सिविल मैटर में जब आप क्रॉस
जी
करेंगे तो सिविल मैटर
जी
में जो है एविडेंस ऑलरेडी जो है वो दिए रहते हैं,
एग्जिबिट हो जाएगा।
एग्जिबिटेड रहता है। जो
जी
एविडेंस दिया रहता है वो भी एविडेंस वकील साहब के द्वारा ही तैयार किया गया रहता है।
जी
उसमें भी आप सवाल निकाल के ले जाइए। मान लीजिए अगर किसी से आपको पैसा लेना है,
जी
ठीक है ना, तो
जी
जिसको पैसा लेना है उसने पैसा दिया या नहीं दिया या जबरदस्ती आपको फंसाया,
जी
ये देखना है आपको। अगर मान लीजिए कई बार ऐसा भी होता है कि भाई किसी ने चेक दे दिया या किसी ने प्रोमिसरी नोट दे दिया,
जी
तो कैश में पैसा दे दिया, फिर भी जो है उस चेक को मिसयूज करता है।
जी
तो ये आपको वो अपने एविडेंस में कहेगा कि मैंने आपको इतने पैसे दिए थे, इसके पैसे के अगेंस्ट आपने आप मुझे चेक दिया। कई बार ऐसा लोग लिख देते हैं कि भाई आपने मुझे, मैंने तुमको कैश दे दिया, उस कैश के बदले आपने चेक दिया,
जी
या फिर मैंने आपको कैश दिया, आपने मुझे प्रोमिसरी नोट इशू कर दिया,
जी
या फिर मैंने आपको जो है चेक दिया था, आपने बोला था एक राइटिंग में साइन करवा ले, आपने बोला था कि आप जो है मुझे इतने दिन में दे देंगे। ये सब चीजें जो है एविडेंस पे आने के लिए आपको सबसे पहले उनसे पूछना पड़ेगा, भाई आपने कैश दिया तो कैसे दिया, आपने जो है आपके
जी
पास इतना पैसा आया कहाँ से, फिर आप करते क्या हैं, आपका सोर्स ऑफ इनकम क्या है, आप आईटीआर भरते हैं या नहीं भरते हैं, आपने उस दिन जब पैसा दिया तो पैसा कहाँ से निकाला, आपको पैसा वो कहाँ से आया। भाई 2 लाख रुपए कहीं अगर किसी को देंगे तो कहीं ना कहीं से घर में तो थोड़ी रखा है,
जी
जैसे
श्योर
बैंक से
श्योर
निकाला होगा आपने, या फिर किसी से उधार लिया होगा, या 10 लोगों से कहीं कोई सोर्स ऑफ इनकम होगा। तो ये सब
जी
काउंटिंग आपको प्रूव करने की जरूरत होती है। जब ऐसे ऐसे सवाल जब पूछेंगे तो वो गोल गोल घूम जाता है। भाई 2 लाख रुपए
जी
आए कहाँ से, मेरे को क्या पता। मतलब ये फिर आपका सजेशन आ जाएगा। मतलब मेरा कहना ये गलत है कि भाई आपके पास 2 लाख रुपए की सोर्स ऑफ इनकम थी ही नहीं।
जी
तो वो जो है ऐसे सवाल जब आप पूछोगे तो वो अपने जो है उसमें घूम जाता है, फिर सही निकल के आ
जी
जाता है। जो सही निकल के आ गया तो आप अपना केस जीत जाओगे, क्योंकि उसने कहा था कि
जी
मेरे को 2 लाख रुपए लेने थे और बाद में उसने कह दिया कि भाई 2 लाख रुपए तो मेरे पास थे ही नहीं, मैं कहाँ से देता।
जी सर
तो ये सब सवाल जो है बड़े रिलेवेंट होते हैं, और इन सब सवालों को प्रॉपर फ्रेम करके, प्रॉपर पढ़ करके एविडेंस से ही आप सवाल पूछना चाहिए।
जी
क्योंकि एविडेंस से बियॉन्ड जो है आप ट्रेवल करेंगे तो भाई कोर्ट भी बोलेगी कि भाई दिस इज नॉट द रिलेवेंट क्वेश्चन।
जी
समटाइम्स
सर
जो है आपको लगता है कि रिलेवेंट क्वेश्चन है, जज साहब का रिलेवेंट क्वेश्चन नहीं है, तो फिर आप जज साहब को भी समझाइए कि नहीं माय लॉर्ड, दिस इज द रिलेवेंट क्वेश्चन बिकॉज दिस दिस इम्पैक्टेड दिस इशू। तो मैं
जी
इसको जो है क्वेश्चन आंसर फॉर्म में लिख लेता हूँ। मेरा क्वेश्चन ये है, इनसे बोल दीजिए कि जवाब दे दिया, अगर जवाब नहीं देना चाहते तो मना कर दें।
जी सर जी
तो यू कैन मेक ए रिक्वेस्ट टू द कोर्ट कि नहीं,
जी
हो सकता है बिकॉज देखो समटाइम्स ऐसा भी हो सकता है कि भाई कोर्ट को लगता है कि आपका रिलेवेंट सवाल नहीं है,
जी
लेकिन जब आप कोर्ट को समझाओगे कि नहीं माय लॉर्ड दिस इज द रिलेवेंट क्वेश्चन ओनली बिकॉज ऑफ दैट, कोर्ट भी समझ जाती है हाँ ठीक है भाई, ठीक है जवाब दो, हाँ नहीं जब ऐसा भी हो। लेकिन अगर आपको कोर्ट कुछ बोल देती है, आप घबरा से जाते हैं कि नहीं नहीं आज जज साहब कह रहे हैं नहीं रिलेवेंट नहीं है तो नहीं होगा, ऐसा नहीं है
जी
कि भाई जज साहब आपके फाइल के बारे में उतना ज्यादा जानकारी नहीं रखते हैं जितनी आप जानकारी रखते हैं।
जी
लेकिन जज साहब को आपको समझाना पड़ेगा नहीं मतलब दिस इज रिलेवेंट क्वेश्चन, और उसको एक्सप्लेन करने की कोशिश करिए और कन्विंस करने की कोशिश कीजिए कि नहीं जैसा भी रिलेवेंट है और इसको जो है मेरे को पूछने दिया जाए। अगर अगर आपको लगता है ये रिलेवेंट नहीं तो उसी से मिलता जुलता दूसरा सवाल पूछ लीजिए।
जी
2-3 सवाल जब आगे पीछे करके पूछेंगे तो जज साहब भी कहेंगे ठीक है जी जवाब दे दो कोई बात।
जी
ऑल आर द टेक्निक्स, क्रॉस एग्जामिनेशन की स्पेसिफिक किताब आती है, उस किताब पे भी बहुत सारी चीजें लिखी रहती है, उसको पढ़िए कि कैसे व्हाट इज द टेक्स एंड टेक्निक्स एंड आर्ट ऑफ द एडवोकेसी, आर्ट ऑफ द क्रॉस एग्जामिनेशन। क्रॉस एग्जामिनेशन इज द आर्ट।
जी
और
सर
बहुत सारे लोग कई सालों प्रैक्टिस करने के बाद भी इस आर्ट को नहीं सीख पाते।
जी
तो ये
मेन हमारी डिग्री होगी नहीं डिग्री होगी, इट ऑल डिपेंड्स ऑन
यस
एविडेंस
इट
एंड
इज
क्रॉस।
ऑल डिपेंड्स अपॉन एविडेंस। क्रॉस एग्जामिनेशन, क्रॉस एग्जामिनेशन इज वेरी इंपॉर्टेंट, क्योंकि जो आदमी जो है विटनेस बॉक्स में आता है वो खुद जब बोलता है तो वो जो बोलता है और जो लिखा रहता है दोनों में फर्क हो जाता है।
जी
हम्म, ये
थैंक यू
कहानी।
सर थैंक यू।
थैंक यू। और एनीवन एल्स प्लीज। जी दीपक जी। दीपक जी, और किसी को कोई सवाल हो तो पूछ लीजिए भाई, ये नहीं तो फिर जो है, क्योंकि अब 36 हो गया, कुछ हो तो डिस्कस कर लेते हैं, तो नहीं हो तो देन वी विल वाइंड अप। बताइए प्लीज। बोलिए भाई, हाँ नहीं कुछ तो बोलिए। सभी लोग वीडियो ऑन कर लीजिए जरा एक बार। रिक्वेस्ट ऑल ऑफ यू टू स्विच ऑन योर वीडियोस। जी दीपक जी, कुछ कुछ कहना चाह रहे हैं कुछ? आपका माइक।
हेलो,
जी जी दीपक जी बोलिए प्लीज।
आवाज आ रही है सर?
हाँ भाई, हाँ भाई।
जो जिस पे भी हम डिस्कस कर रहे थे सर, इसी
जी,
पे जो नया नया एक्ट है उसका इससे कोई रिलेटेड चेंज है इसमें, इसी पॉइंट पे जो अभी विवेक जी ने क्वेश्चन किया था।
वो लीडिंग क्वेश्चंस पे कुछ जो है चेंजेज हैं।
जी हाँ, वो तो एक बार मैं उसी को एग्जांपल के साथ जानना चाह रहा था सर।
जैसे कुछ क्वेश्चंस होते हैं ना जो लीडिंग क्वेश्चंस होते हैं।
जी, जो इसमें बीएसए में चेंज है और पुराने से कुछ नया है, ओल्ड जो अपना इंडियन एविडेंस एक्ट है सर।
जी जी जी, इसमें जो है ना, जैसे पहले क्या होता था कि भाई कुछ ऐसे क्वेश्चंस होते थे जो लीडिंग क्वेश्चन होते थे, जिसको जज साहब लोग जो है था वो कह देते कि नहीं भाई ये लीडिंग क्वेश्चंस है, यू कैन एड्रेस दिस इशू व्हाइल आर्गुमेंट। कि आप जो है इस जो आपका लीडिंग क्वेश्चन है आप अपने आर्गुमेंट के समय पे कर लीजिएगा। लेकिन ये जो बीएसए में है, बीएसए में जो है उसको जो है थोड़ा सा ब्रॉडन कर दिया गया है कि नहीं जी, आप लीडिंग क्वेश्चंस भी हैं तो भी आप अपने क्रॉस एग्जामिनेशन में पूछ सकते हैं उसको जो है, क्योंकि जज साहब उसको मना नहीं कर सकते। स्पेसिफिक जो है कुछ नए प्रोविजंस इसमें ऐड किए गए लीडिंग क्वेश्चंस के बारे में। नहीं क्लियर हुआ?
ना हो गया क्लियर, यही था मेरा।
थैंक यू, थैंक यू। जी अमित जी, कुछ पूछना चाह रहे हैं आप भी?
सर अभी तो कुछ सवाल नहीं है, आप हमें तो बहुत शागिर्दी करनी पड़ेगी आपकी, तब कुछ सवाल ववाल समझ में आएंगे हमें तो।
अरे नहीं नहीं, चलिए सभी सभी साथियों का बहुत बहुत धन्यवाद। और आप लोगों ने अपना 1 घंटे का समय हमें दिया, हम आपके जो है आभारी हैं। अगर किसी और साथी को कोई सवाल हो तो पूछ सकते हैं भाई, नहीं तो फिर आगे वाइंड अप करते हैं। फिर अगले 4th सैटरडे का जो है हम अपने एक बहुत लर्नेड साथी को इनवाइट कर रहे हैं, जो कि उनका एक्साइज और कस्टम में बड़ी अच्छी अप्रोच है। और ही वाज द सीईओ ऑफ द लावा, जो हमारे नेक्स्ट सेशन लेंगे। तो उनका एक्साइज कस्टम में अच्छा पकड़ है। और हमारे दीपक जी आप जरूर ज्वाइन करिएगा, क्योंकि आप भी एक्साइज और कस्टम से जो है बहुत ताल्लुकात रखते हैं। आपका पूरा एरिया जो है उसी फील्ड में रहा है। ठीक कर रहा हूँ दीपक जी, नहीं कर रहा हूँ?
राइट सर, राइट।
तो
कमिंग सैटरडे सर,
4th सैटरडे, ये हमारे ख्याल से 23 तारीख होगा।
24।
24 है?
हाँ जी सर।
हाँ 24
24
तारीख
अगस्त
24 तारीख है। तो उसमें जो है एक्साइज और कस्टम पे ही कवर करेंगे, क्योंकि उनकी उस फील्ड की एक्सपर्टाइज। तो फिर हम लोग उनसे भी थोड़ा अपना ज्ञान जो भी हो सकता है देंगे। और हमारे कोई साथी अगर आप लोग कोई अपना ज्ञान देना चाहें तो भाई आप जरूर हम लोगों को भी थोड़ा अपने ज्ञान से अवगत कराएं। दीपक जी, कभी आपका एक्सपर्टाइज किसी फील्ड में हो तो जरूर हमारे प्लेटफॉर्म पे आप बोलिए। ठीक है, सभी साथियों का धन्यवाद। नमस्कार। यस मिस यासिका।
Yes, sir. Yes, sir. I, so shall I go with the vote
Yes,
of
yes,
thanks?
yes, yes, yes.
I stand here today as proud and grateful to express my heartfelt thanks to all those who have made this session possible. I would like to start by thanking Vidya Vijay Foundation, who have always been supportive and encouraged us to strive for excellence. I would also like to extend my gratitude to Dr. Nityanand Singh, who have been our guiding lights, imparting wisdom and knowledge to us and nurturing our talents. Their unwavering support has been instrumental in our growth and development. I would like to express my appreciation to our guests who have taken time out of their busy schedule to grace this occasion with their presence. Your presence has added an extra spark to this session and made it even more special. I request everyone to share their email IDs and names for the certificates. Thank you.
धन्यवाद साथी। फिर अगले शनिवार 24 तारीख को मिलेंगे।
थैंक्स सर।
थैंक यू, थैंक यू, थैंक यू।